Mike, you're good to go.
Okay, good morning. I'd like to call the meeting of the Policy and Personnel Committee to order. It is 9:02. Stephanie, would you please take attendance?
Yes, thank you. Good morning, everyone. Ava Bermuda Zimmerman has not joined us yet. Ellen McKitterick has not joined us either. Mike Soltis,
Here.
Holly Williams has not joined us yet. And David Salazar Austin.
Here.
All right, unfortunately, we do not have a quorum at this moment.
Okay, thank you, Stephanie. I would like to welcome and thank the members of the public for joining us today. Since we do not have a quorum, we will not address item number 1 on the agenda, which is the review and approval of the March 4 minutes.
Excuse me, just for a moment. We have Holly joining us right now. Good morning, Holly.
And with Holly, we now have a quorum.
Okay, so good morning, Holly. Welcome.
Morning.
Now that we have a quorum, we will deal with item the review and approval of the March 4, 2025 meeting minutes. I'd like to ask the committee for a review of those minutes and a motion to approve. We have a motion to approve, please.
So moved.
Second.
Okay, all in favor?
Aye.
Aye.
I will abstain. So the motion carries. Thank you. Moving on to the next item on the agenda, the proposed revisions to the consolidated policies. Michael, would you please lead us in the discussion of the proposed revisions?
Absolutely. Thank you, Mike, and good morning, everybody. I'm going to share my screen. Hopefully the committee all received a copy of the red line changes to the consolidated policies. I'm not going to go through each item in detail, but I'm happy to address any specifics if we want to talk about them. I was going to talk about it at a more high level. There wasn't anything sort of game-changing or controversial in the changes to consolidated policies that we are recommending. I've broken it down into these 6 categories. The first one is probably the biggest as far as word count perspective. Any folks who were on the board back in the early days in 2019, 2020, they may recall that we had, the board had adopted a glossary of terms. It was one of the first things that the board did. It was basically taking definitions from various aspects of FMLA, whether it's the statute, the regulation, case law, DOL guidance, and sort of adopting them as formal definitions for our program as well. And the glossary has sort of sat out there as one of the references that we use. Later on, we adopted the consolidated policies, which also had a definition section. And so we sort of had these 2 lists of definitions in various places. With the change in our statute last October, incorporating sexual assault into the Safe Leave program, we were thinking about, okay, we have to add the definition of sexual assault. Do we add it to the glossary? Do we add it to the consolidated policies? And the decision was made, why don't we just incorporate the glossary definitions into the consolidated policies so we have one definition section going forward, and then we can sort of retire the glossary. So most of the definition in the glossary we ended up putting into the consolidated policies, which is why you see a lot of red lines in that first section. Although we didn't do all of them, and I'll talk about that in the next slide. And we can have a discussion about whether we need to incorporate more. The second category of changes, it's a very small change around employer eligibility. It's really clarifying something that already existed. For RESCs, which is Regional Educational Service Centers and state charter schools, they are basically treated the same as local and regional boards of education in that they're exempt from the program unless they opt in. We just added language to our policies to clarify that they have that right to opt in the same, since the exemption applies the same way for local or regional board of education, we want to make it clear that they have the same power as those folks. So if they have a unionized workforce, they can collectively bargain to the program. The third item relates to contributions and the Social Security cap. For contributions under our program, employees are not required to contribute after they, for wages above the Social Security cap for that year. Most of the time when an employee, if they change jobs from one employer to another employer, that second employer basically starts at zero for the contribution limit because they don't know how much was paid by that prior employer. So they, at the end of the day, this applies to both FICA and to our program. They contribute back at zero. They might have contributed more than the total wages they paid that year times 0.5. And what ends up happening for us is we refund those employees at the end of the year when they reach out and request a refund because they've over-contributed to our program. So that's the way it normally works. There is a limited circumstance where there is a change of employers, but it's not really a change of employers. If the employer restructures, there's a merger and acquisition such that one employer takes over the business of the old employer, under IRS rules, they can sort of consider themselves one employer. And if that happens, we want to make it clear that for our purposes as well, we can consider them one employer and not have to start back at zero because really the employee didn't change jobs, just the employment situation changed due to no fault of their own. So it's helpful for employees. They don't have to over-contribute. They don't have to request a refund. It's helpful for us because we don't have to actually go through the process of issuing a refund. We just never collected the money in the first place. And so that's just mirroring what happens under FICA. Fourth category is about claim documentation. This is allowing us to confirm details related to a claim in writing, electronically, or verbally, just reiterating something that we think has always been the case. This is helpful for us, particularly when it comes to pregnancy claims, because we do allow the option, and most claimants take advantage of this, of us reaching out to the healthcare provider over the phone and confirming details of the birth. Much faster process for claimants. So we're just adding the language to make it clear that that is acceptable in our policies. It also can have some helpful uses if there's an incomplete med cert submitted or other incomplete documentation. We could reach out to that person and fill in those details over the phone rather than making them fill out a brand new form. So all about efficiency of operations and making sure our policies reflect that. The fifth item on the list is probably the biggest item as far as helpfulness to the public, although it doesn't have a major change to our policies, and that's the employer portal claim access project. Essentially, now we have the capability of allowing employers to see some information about their claims of their employees through their portal. It doesn't have everything about the claim, but it essentially has the approval or denial, the dates that were approved, and the amounts of any payments. The primary purpose of this is so that employers can correctly coordinate benefits if they're trying to top off the benefit and avoid exceeding 100% of those employees' wages. As far as the policy language, it's mostly around the process of gaining access because we don't want to give it to just anybody who's listed as a contact for the employer. We want to make sure that it's someone at the employer who has a right to see his information. So there is a process where they submit a request, they fill out a form. Essentially, we ask them to confirm wage information that they wouldn't otherwise know unless they're at a certain level of the organization. And once they submit that, we confirm that wage information and we'll grant them the access. We've been sort of slow walking this a little bit. We haven't made a grand announcement about it because we have been a little bit concerned that we're going to get 100,000 requests that first week and we never be able to process it. So we've been slowly releasing this. Since this is a public meeting, this may be another iteration of a batch of employers finding out about this, but we're slowly going to add more and more information. It's currently available. The information is on our website. Maybe we'll make an announcement in the future about it after we sort of go through this process and make sure it's working out smoothly. The last category is about third-party authorization. So this is a circumstance where employees are not able to file their own claims and sort of what options would we allow for a third party to act on their behalf. Previously, we've been sort of addressing this on an ad hoc basis and trying to figure out for each claim what's the appropriate circumstances. The fortunate thing about our program is there's very little that the employee themselves need to fill out for a lot of these claims. They need to obviously make the initial claim filing, but most of the documentation we receive is from somebody else, their employer, their healthcare provider, another third party. So there isn't necessarily a need for a lot of details from the employee themselves. But we do need to formalize what that process is. Should there be someone who passes away but has a valid claim, someone's in a coma or is otherwise not available. So we drafted language in our policy to formalize that. There's a few options available. There's a third-party authorization form that's always been part of our program. We'll also accept court appointments of legal guardianship, the power of attorney. If there's, in the case of a claimant who has passed away, we can accept the executor of the estate acting on their behalf. And we have this sort of catch-all provision. If a healthcare provider certifies that the employee is unable to participate in the claims process and also their medical condition prevents them from completing that third-party authorization form, we could, in that circumstance, allow another individual to act on that person's behalf for that claim. At the end of the day, the payment still will only be made to the claimant themselves or to their estate. We would not allow the third party to be the recipient of those benefits unless required by law or court order. So it's basically formalizing a process that we were trying to address on a case-by-case basis previously. As I said, hopefully nothing too controversial. Before I go on to sort of some of the details about the definitions, curious if anyone had any questions about these. All right, so now,
I'm sorry, Michael, could I just jump in for 1 second?
oh,
So just on the employer claim access, just want to be clear, the information that the employers can see on the portal is basically a rolled up report version of what they receive at the time a claim is approved. So when a claim is approved or denied, a notice does go out to the employer with that information, but they get it on a person by person basis. And the request that's been made by many employers is it'd be very helpful if we could get this in a report so we could look it up instead of having to keep these notification emails kind of and create our own report separately. So they're not getting anything more than they've received before. They're just getting it in a different format.
thank you so much, Aaron, for that clarification. Okay. I hinted this before. I want to open up to the committee for their thoughts. This is really a question about sort of legal philosophy and drafting policies or regulations. One of the things we encountered when trying to incorporate the glossary terms into the consolidated policies was there really a need to have this many definitions, particularly if the definitions come from another area of law? So in our program, we have some definitions in the Connecticut Paid Leave Act itself. So like definitions of employer, definitions of wages, things like that. There's also some that are referenced in the Connecticut Family and Medical Leave Act. Things like what does it mean to be a son or daughter or a grandchild and all the family relationships that qualify. There's also regulations tied to both of those, the federal and Connecticut FMLA, that provide further definitions, such as what does it mean to have an incapacity, things like that. And then there also are some citations in our law that cite to an entirely different section of the Connecticut Code. For example, the definition of municipality is in Title VII. The definition for family violence is in Title 46B. So when we were thinking about what do we move into the consolidated policies, we had a philosophical question of, should we just repeat definitions that are already in the code or regulation somewhere else? Obviously, the pro side of doing that is it's helpful for the public. They can sort of see all the definitions in one section. They don't have to refer to other areas of Connecticut statute or regulations. The downside, obviously, is if there's changes to those underlying laws, we would then have to update the consolidated policies and go through this process to revise it, which could be a little bit time consuming. So I was curious if any folks on the committee had any perspectives on this, opinions, if you have strong feelings one way or the other, which way to go. Should we include those definitions? Should we not include them? Should we vary based on importance, how easy it is to use? And then I said proximity to Connecticut Paid Leave Act. I meant like for the definition of municipality being an entirely different section of the law, or definition of family violence is in family law, and I think like sexual assaults in the criminal code. Should those be the ones that we carry over because they're sort of much further away from the Connecticut Paid Leave Act? So sort of opening up to the committee for your thoughts, comments, questions.
All right, anyone have any
Well,
thoughts?
I have a question. This is Holly. Well, so the intent of the consolidated policy is to have a useful resource for outside consumers, be it employers, employees, policymakers, whomever, right?
That is one of the primary intents. I think there's also, there's some things that were not specifically defined in the statutes that we need to add definition to or clarity to. But yes, absolutely. One of the primary goals is public education and making it easy for them to understand our program.
So while I love, reading statute at my leisure, I do think that because that's the stated goal, and definitions in statute tend not to be too long. I do think there's like a educational benefit of putting the statutory citation in your policies, but then including the actual portion of the statute, in my opinion. So I think that's option one. Because the stated purpose is really kind of education. That's just my thoughts on that. I think as a public facing entity, I think erring on the side of understanding that somebody may not have the ability or option to kind of go digging through statute, particularly because the statutes, if you're not used to looking at them, then you're not really sure how to search them and when to search them and what you're looking at, right? And so that's just my opinion from like a educational standpoint, that there's no harm in pulling the language into your policies and putting the actual reference. Then if somebody wants to go digging further, they can.
Thank you. Yeah, that's definitely one of the things we were considering. For example, the definition of son or daughter, knowing that that includes biological children, in loco parentis, stepchildren. You may not be aware of that if you're not, spending time in the FMLA code. So putting in the consolidated policy would be helpful for that.
Okay. David, any thoughts?
I agree with that approach. I think that if we were referring to just one act, then repeating them would be pointless, or not pointless to Holly's point, but maybe not worthwhile. But because it's so many different acts, I just think it's easier if you put them all in one place. It is going to put a little bit of a burden on you guys to, continue to update them, as they may be updated by the underlying laws. But I think, the definitions don't change a ton. So I wouldn't anticipate you guys having to do a lot of legwork on that front.
Absolutely.
Okay. Yeah, well, I think we're unanimous in that view, then. I always think there's a benefit of a self-contained document so that non-lawyers can have it in front of them, can read it. If we just had references, some people are going to say they're going to bail out and they're not going to go check the references. So for reasons Holly and David said, I concur.
Oh, excellent. So unanimous. Great. I'll have to make some revisions because I did not include certain definitions that were in the glossary in the consolidated policies. But I think we can do that during the public notice and comment period, because I know this is a quick turnaround between the committee and the board meeting, so I don't want to confuse the rest of the board. So I think we can keep as it's currently drafted, keep that for the board meeting in 2 days, but then make the adjustments during the public notice period before official adoption, if that's okay with the committee.
Okay, that sounds like a good plan.
All right.
And then just so I'm clear, we're going to reference both the citation, so whether it's a statute or a regulation, and repeat that definition. So it's very clear kind of what our source is, as well as the actual plain language, or hopefully plain language version that's in the statute. So I think there'll be a little bit of adjustments that will need to be made on that front too, Michael.
Absolutely.
Great. I think this is, we really appreciate your feedback on this. Internally, we were going back and forth.
Yeah.
Does it make sense? Does it not make sense? What should we do? So thank you for that feedback.
Yeah. Well, the other side of the argument is sometimes the document gets so lengthy and unwieldy because it has all of the statutory language. But not to repeat what we said before, I do think you're better off having it all in one place.
Yeah, and sort of David's point, it does add a little bit of work to our plate at the authority, but it's manageable. It's not, we're not changing the law every week, so I'm happy to take that on. I did have one more slide. This is just sort of level setting where we are for the year. I looked at our meeting back in January of what policies we had as priorities. So there were 6 of them. I think it's 7 of them back in January. 2 of them were completed, updates to our private plan policies and the employee handbook. One of the items we identified was the third party's ability to file paid leaves on someone's behalf. That's in this consolidated policies. Got a couple that we've got on the calendar upcoming, private plan audit guide revisions, probably, and plan of operations bylaws review will probably be either, we'll share those revisions in the July meeting or potentially September meeting. And then, assuming we have time at the end of the year, we've got the conflict of interest policy. That's sort of enhancements beyond what the state ethics rules are, to address things where maybe there's not a financial interest, but maybe there's just sort of a personal interest that someone's connected to. So if you have a best friend growing up who has an appeal of a paid leave claim, I probably should not be the person who's handling that appeal because I'm connected to that person, even though it's not technically a violation of the current state ethics. So we're going to add a policy language to that. And then, not the biggest priority, but according to our statute, we need to have a policy related to the solvency of the trust fund and whether that will impact the ability to approve private plans going forward. At the moment, private plans are such a small part of our overall program, but at a certain point, maybe it becomes impactful to the solvency. So still a lot of thought to go into that. I don't know if that one's going to get done this year, but we did identify it as at least one we're going to talk about. So that is it for my presentation. Happy to take any questions the committee may have. Otherwise, I think we're good to share the consolidated policy with the full board Thursday.
All right, any questions for Michael? Okay, thanks, Michael. It's good to see a roadmap for the rest of the year, so I appreciate that.
Thank you so much.
Okay, moving to old business. Is there any old business anyone would like to discuss? Seeing none, any new business? Any new business anyone would like to discuss? And seeing none, we move to adjournment. May I have a motion to adjourn?
So moved.
Second,
Second.
all in favor?
Aye.
Aye.
Opposed? Abstentions? Okay, the motion carries. Thank you. The meeting is adjourned. It is 9:25 a.m. Thank you for your time this morning. Enjoy the rest of your day.
Thank you so much,
Thank you.
everyone.
As
Okay.
well.
We'll see you on Thursday.
Yep.